Let me just say good evening, everyone, and welcome to tonight's, I'm calling it, special edition of Analyze This Mess because somebody had to say it. Tonight, I'm sharing something serious and unprecedented, something that directly affects my rights as a plaintiff and the integrity of the federal court process. I recently issued a legal subpoena, yes, a proper and court authorized subpoena to obtain relevant records in my ongoing federal case. That subpoena was directed to Block Incorporated, also known as Cashapp. But instead of a straightforward legal response, what happened next shocked me. I'll give you the background. We'll get into it so you'll know the timestamps, the dates, how it flowed. A person hiding behind the name John Doe filed a motion to quash the subpoena. They didn't reveal their identity, and now they're asking the court to prevent me from obtaining the evidence I lawfully requested. They're even asking the court to permanently seal their identity from me. This isn't just about games or drama. This is about due process, the right to uncover the truth, and holding people accountable under the law. So tonight, we're going to break down what a motion to quash is, why this anonymous filing raises serious concerns, and what it could mean if people are allowed to block subpoenas without revealing who they are or whether they even have legal standing. Let's make this clear. This isn't about harassment. This is about discovery. It's about someone trying to block access to financial records tied to a public-facing account that may be relevant to a defamation and harassment lawsuit. And it's happening while they hide behind a false name. And yes, I'm going to read you parts of this sealed motion to quash. We'll say quasi because they are asking it to be sealed. This part is not, because the court will have to decide if justice can be served when parties hide from accountability. It is now 10:30. I like to timestamp when I begin. So, that's right. You heard that. Not only filing to seal, but also other things within this motion to quash. You ready to get into it? Just breathe. So let me just tell you this, just so that we can get some key legal talking points out of the way. A court authorized requests to obtain evidence relevant to a case. That's what the subpoena was for. I issued mine under Federal Rule 45 legally and properly. What is a motion to quash? It's a legal objection to a subpoena. But to file one, you usually must show you are directly affected and identify yourself. Why is this filing for me? We'll say problematic because it was filed under a fake name or pseudonym, John Doe. Not Jane, John Doe, who claims to be uninvolved in the case, yet asks to block discovery. It's problematic because it demands secrecy. It wants the court to seal their identity from me, the plaintiff. Why it matters? Because if anonymous people can block legal subpoenas, no plaintiff could ever get evidence. And it undermines the principle of open courts and accountability. What am I doing about it? Thus far, I filed a motion to compel the company to respond, but now there's some additional preparation to ask the court. I haven't filed it yet, should I tell you? I will say another motion. I'll continue to defend my right to due process with respect and in accordance with the law. Let me just look something up. And while I'm doing that, And yes, I'm going to show you. It was filed in federal court. It just came on the docket today. It's dated April the 25th. And I think it was electronically filed. This is the first time that I know that anyone on this platform has gotten any kind of response in a court of law like this, a motion to quash anything. I'm talking about from Dani Robertson or anyone related to her at all. Because whoever this individual is, it was not Block. Remember we talked about, I said I hadn't heard from anyone. I hadn't received anything. I couldn't find anything on the docket. And then this comes on today. Apparently, it has gotten the attention of somebody because it has risen to the level that if it's not quashed, then Block is going to release some information. Not sure, don't want to get ahead of my skis yet, but Block is and was prepared. We're talking about the individual or individuals who are on the Truth Teller Dani Cash app. It's follow the money, but I want to stick to what I said. Let me give my disclaimer before I begin to read it. A legal disclaimer. The content discussed tonight is based on publicly available filings in a federal lawsuit in which I am the plaintiff. I am not accusing anyone of a crime or wrongdoing beyond what is alleged in my official court pleadings. Any documents or motions discussed are part of the case record, and my commentary is intended for public education, transparency, and legal commentary under my First Amendment rights. I am not providing legal advice. I am not an attorney. And any opinions expressed are my own as a pro se litigant. If anyone mentioned feels they've been misrepresented, they are welcome to respond directly or through the appropriate legal channels. This is about truth, accountability, and transparency, and I stand by that. I stand by that. That was my disclaimer, legal disclaimer, before I get into this. I need people to be respectful in the chat. Okay. I know people are watching. I want to say this too. Inside of this motion to quash is a statement that makes reference that they had not received a subpoena until, or knew about this until Block notified them just, well, the dates, I'll read it. Okay. But somehow, I'll read it. Let me just read it. I don't want to give my commentary just yet. Because I want to stick to the facts, because they are also asking the judge. They are also asking the judge. Let me pull it up. Let me just pull it up. Let me look at this statement, and then I'm going to pull it up. It's a motion to quash subpoenas, plural, because there were 2 filed. I told you about one that I had to refile because I inadvertently put my former attorney, who I have not retained as of this minute on this case, because we hadn't cleared the first hurdle. It's now a case. Okay. They filed a motion to quash subpoenas and for protective order, filed by a non-party John Doe. Mm-hmm. They're also making statements of violation of court guidelines, pattern of abuse, and justify. They're asking the judge to sanction me. You heard right. They're asking the judge for sanctions or penalties to be imposed against me. Mm-hmm. This is an anonymous person who's asking for everything to be sealed, for any future subpoenas to be blocked. You heard that right. You're going to see it. I just wanted to say it. Let that sink in. Let that sink in. Not only motion to quash. Motion to quash and protective order. And sanctions. Penalties. This is why I said this is serious. I don't think anybody yet has gotten any kind of reaction like this so far from anybody related to Dani Robertson at all. I'm talking about a legal filing in the federal court, someone under the pseudonym John Doe that does not want this information to be revealed, because whoever it is, let's just keep it, legal. There's something in or related to that Cash App, whoever's on that Cash App, that it might just bring me, the plaintiff, a little bit closer to holding the true person accountable because somebody responded. Come on. We got a response here, even if it's a John Doe. Oh, they didn't ignore this one. And it also says to me, somebody received that summons and complaint, because all of this will be able to be subpoenaed or found out, track it, whatever we need to do. And I'm going to say we, because eventually it will be. To cross-reference, and guess what? They put an address in the motion to quash in Atlanta, but I don't know if that's not related to a post office box. Hear me out. They put a phone number, they put an address in Atlanta. Are you guys ready? I think we need to take this. I'm taking this serious, guys. If nobody else has taken me serious, then they need to take me serious tonight. Because they're asking for sanctions and a penalty. This is in the court of law. In federal court, I will show you this is real. Okay? Yes. So let's take a look, shall we? Let me put up this cover. Oh, get your glass of wine. It's 10:49. It's Tuesday night. It's Analyze This Mess, because someone had to say it. Dani Robertson, motion to quash John Doe, I'm pulling this up, guys. First of all, let's just throw this up. Motion to compel. I filed it on Friday. As I've stated before, I got a busy week ahead of me. I have other motions that need to be filed straight away. Okay. I also have to file for default judgment. I also have to issue other subpoenas. Give me a second. And when I say I have to issue, I have to get the court's approval signature, and then they have to be served. Because this is discovery. Let's take a look. Hang on. I'm going to look at this. And there's part of it. Well, wait a minute. Hang on for 1 second. Let me make it full blown all the way without any headers. Okay. Let's you can see the first page. Okay. Let's roll it all the way down so you can see it. This is fair use. It's for education. It's for criticism. I've already given my disclaimer. Okay. You can see the case number is 524CV13435. It's 9 pages. It was filed April 25th. Okay. In the United States District Court, Eastern District of Michigan. Sabrina Evans et al. Plaintiff versus Daniel Robertson et al. Defendant. Motion to quash subpoenas and for protective order filed by non-party John Doe. Okay. If there's something in it that I need to do this or block something, I may do that. I have not read every word of it, but I've read. I said I needed to read over this. Okay. So let me read it. It states, I, John Doe, respectfully move this court to quash 2 subpoenas issued by plaintiff Sabrina Evans to Block Incorporated, cashapp. Which improperly seek personal and private information belonging to me, a non-party. Let's let you see this. A non-party. I further request a protective order to prevent further abuse of the discovery process and potential misuse of subpoena power. By the way, you can email me right now at unwinewithteddy@gmail.com. Limited appearance by non-party. While I am proceeding under the pseudonym John Doe, I am not a named defendant, a Doe defendant, or otherwise involved in this litigation. I am the legal account holder whose financial information, legal name, and personal identifiers are being improperly sought through these subpoenas. Let's just park it right there for a moment. For me. So the person responded, says they're not a named defendant. Remember, I've got Jane Doe's 1 through 10. Okay. They put John Doe. All right. Jane Doe, John Doe. I can always add other Does. They are placeholders. Okay. And by the way, I'm not here to litigate this because I'm not an attorney. This is my opinion and reaction. This individual says, I am the legal account holder whose financial information, legal name, and personal identifiers are being improperly sought through these subpoenas. I have my own distinct legal interests in protecting that private data. Plaintiff is a stranger to me, and my information has no relevance to the claims in this case. I'm appearing solely to protect my rights as a non-party whose confidential records are being unlawfully targeted. So I'm asking or subpoenaed block for information. It's Truth Teller Dani. That's the name. That's the account. I'm not asking for any other accounts. Unrelated to Dani Robertson or Truth Teller Dani or any of whoever is linked to this particular account. This John Doe, I'm appearing solely to protect my rights as a non-party whose confidential records are being unlawfully targeted. They said they don't know me. I don't know them. They said I didn't serve them. I subpoenaed the company. I subpoenaed Block. Let me keep going on. Just marinate in that for a moment. And think about this wording and who did this. Remember, I said in the beginning, I am not making any accusations. I don't know. And I said it the other night. Because I don't know who these people are. But somebody, somewhere, and you'll see in Atlanta, at least they say it's Atlanta, responded and it's on the document. It's in the history. It's been filed. And they're asking the judge not just to quash, but to fine, to seal, to prevent me. Okay. So let's just read this one. Cup says, so they're not involved, but they're involving themselves as John Doe. They're not involved, but they're involving themselves as John Doe. They're a third party, a non-party. They didn't say third. Look at this. Look at the words. I want you to see them. Anybody can analyze this. I mean, if you're an attorney, you can look at it. Let me take Cups. Let me take your comment down. This is a legal document. Okay. Now let's go through these bullets. Again, I'm just going to read through it. Let's see if I can get through in the next half an hour. Okay. Or less. It says, these statements. 1, I am not a party to this lawsuit and am not being sued in this matter. I don't know that. They're anonymous. They said they've given the judge private information to seal. How we have to think about who we are dealing with. I can't make any allegations. I'm not. This is my opinion. But I have got to think outside the box. I don't know what I'm dealing with. But I know I'm dealing with a defendant who clearly stated, and I have evidence, that they will never be found and that layers have been put into place and they're not anywhere on the account. So the people who are listening to Dani Robertson and sending those cash apps, if she's not getting it, this non-party John Doe who doesn't want to come forward to recognize, tell you're anonymous. So it's kind of unusual for someone anonymous to even file to quash without identifying who they are. Two, the John Doe says, I have no relationship or connection to the plaintiff and no role in the allegations presented in this case. Have you read the allegations? Dani Robertson, have you read the allegations? You've been served. Oh, somebody knows about it. You think? You think not from the beginning? My opinion. 3, I am appearing solely to move to quash these improper subpoenas. I reside outside the state and am submitting this motion via the court's electronic portal due to my inability to appear in person. Do people now understand why it is so important, why it was so important for me to have those recordings of her saying she's never going to be found? She has layers put into place. Trust on that, she said. It will take the police and a lot of digging to find out who she. I need that to support. What's the motivation? Who is this person? Five, I was only made aware of the subpoenas after receiving direct email contact from Block Incorporated, the third-party recipient. I had no prior notice or involvement. Who is this person? So they received an email, John Doe, whose email is attached to the Truth Teller Cash app. So all that can be subpoenaed, but they don't want me to be able to obtain any information. They're even asking the judge to seal this, to block me from even subpoena, because now I want to know. There's other questions. Which email did they use? How did Block notify you? Who did they notify? I can't even think of all the questions. That's why illegal, needs to be by my side. Rare Group says, due to my inability, because they don't live here in Michigan, they can't appear. They can't appear. You know, there is something called video, Zoom hearing. There is something called a Zoom hearing. Remember last year, real quick, somebody had me up in court and then released the hearing. And then somebody, Dani Robertson, the defendant, even posted that private personal protection order hearing. And they weren't involved, were they? How did they get that? Because now we're going to start getting into the case, but we're not going to get into the case. But this is what I'm talking about. Because that's part of the case. A conspiracy to commit fraud. Who else did we involve in that? Let me go on. Let's stick to this motion to quash, motion for protective order. Okay. 6. John Doe says, I am proceeding under the pseudonym John Doe in this motion to protect my privacy. My contact information has been submitted to the court separately and under seal for judicial communication only. How do we even know that what was submitted to the court is a true contact information because it's been sealed or requests or it's been submitted separately under seal? For communication only. They say this complies with procedural rules, and there are rules in the court, and we've got to abide by the rules. I'm not here to obfuscate the going around the rules. John Doe says this complies with procedural rules while preserving my right to proceed anonymously as a non-party. At all costs, let's just park this for a minute. At all costs, no matter what they have to do, it's all about winning. We have all of those statements recording. The way that they think, how they're going to proceed. They said if they ever get in front of a judge, if this ever becomes legal, and said that it would never become legal, that I would never do this, and laughed it off. That they're going to win, that they're going to convince the judge. Remember, I have that. That they're going to be able to persuade the judge because this is what they can do. They've been doing it all their life. They've been told that they are good at persuading people. I have that in her voice. She was boasting how easy it is to convince people. She's always been able to do it. She said that's her basic strong suit. People believe her. She said she's going to win. No matter what it takes. So this is what I'm dealing with. I have a history of dealing with, going around, dealing with someone who doesn't take, go through the front door. They go around through, climb over this or under that. Someone who has publicly stated that they are a liar. Oh, yeah. I have it in her own voice that she lied and that she didn't give two F's about it. I needed that. I don't know what's going to happen in this case. I need to say that. I don't know. I said it before it became a case. It's a case now. I don't know the outcome of the case. I don't know who's behind this account. I don't know what they're going to be able to do, who they are working with. I know that Dani Robertson said she's not going to be found. She laughed it off and said we'll never find her, and said there's layers. I needed that. Let's continue. So you see, what John Doe is saying 1 through 6, not a party, have no relationship connection to the plaintiff. I'm appealing solely to move to Quash. It's improper. They reside outside of the state. They filed electronically. They were only made aware by block. They're proceeding under a pseudonym, John Doe. They want to protect their privacy. Their contact information is under seal in a separate, format to the judge. And they say it complies with procedural rules because they want to preserve their right to proceed anonymously. Dani Robertson said, "I'm an anon." She gave a 1, 2, 3, 4, 5 steps. What it takes to be anonymous. She made a video. She told people she was anonymous. How to stay anonymous. That you need to create multiple aliases. Oh, we got that. You need to create burner phone numbers. There's a phone number on here. You need to have different addresses, email, names. You need to have these things in place so that you cannot be found because you want to be anonymous, remain anonymous. So I look at this. This person says they want to remain anonymous too for privacy reasons. That they need to remain anonymous somehow. Under seal. Who is this person? You mean this could be something, somebody, or some people, or some company, someone, or could it be someone else? We don't know. I need to make it clear another time for everyone who may be coming in right now. Quickly. The content discussed tonight is based on publicly available filings in a federal lawsuit in which I am plaintiff. I am not accusing anyone of a crime or wrongdoing beyond what is alleged in my official court pleadings. Any documents or motions discussed are part of the case record, and my commentary is intended for public education, transparency, legal commentary under my First Amendment rights. I am not providing legal advice, and any opinions expressed are my own as a pro se litigant. If anyone mentioned feels they've been misrepresented, they are welcome to respond directly or through the appropriate legal channels. This is about truth, accountability, and transparency, and I stand by that. And yes, I'm reading my statement that I created. It's my legal disclaimer. Okay. Timeline and background. Let me just put up a cover and look at some of the names or because I don't want YouTube. Remember when I was reading here recently? I put it up, but they struck my channel. And then I had to file for YouTube to lift the strike when I showed my own, legal document. And then they lifted the strike. Okay. So let me look at this next portion. And let's see. I don't have my. I'm just going to do this real quick and see. Let me do something here. See if I can just move it off to the side. That way you can see it. Hang on. I'm just resetting it. Okay, I'll just put it up like this and read it. It says, this is the timeline. March 5th, 2025, plaintiff issued first subpoena to Block Incorporated, demanding extensive private, this is what they're saying, financial data related to Cash App accounts she claimed were associated with Daniel Robertson, aka Dani Robertson. Now, wait a minute. Claiming it's associated with Daniel Robertson. Daniel Robertson has been on this platform for 4 years? And she's used this same Cash App that she shows on her platform. It's on her About page. It's been in her videos. It's everywhere. People have, said that have sent money to this Cash App, truthtellerdani. Even one of my past moderators, who is now, past, is Joy, had a debate about, paying Cash App. Not to mention, guess who else? I'm a member. Remember? So why wouldn't I think that she would be associated with Truth Teller Dani Cash App? But this individual, this non-party, John Doe, says that the plaintiff issued the first subpoena to Block, demanding extensive private financial data related to Cash App accounts she claimed were associated with Daniel Robertson, aka Dani Robertson. Yeah. Yes. Mm-hmm. Subsection. This subpoena included a false attorney contact suggesting plaintiff was represented by a law firm. Talking about my former attorney, Robert Figa, with the phone number, when she was in fact pro se. That part, I am pro se. And when I sent the first subpoena, the only contact information that I put that was incorrect at the time was his email address using my template. Okay. His email address instead of my email address. So Block, with the first subpoena, they responded. Remember, I told you? They responded to him. And he notified me that he shouldn't receive that, that this was sent to him. Okay. And so he was making me aware so that I could take the right steps. It wasn't open. My attorney is a real attorney. He didn't open it. He didn't. And trust me, this was not the kind of email because in order to open it, there's codes and all kinds of things. All right. So they would be able to track that too. So neither myself nor my attorney, I'll keep saying my attorney, Robert Figa, who I've used as my attorney, opened it, but did the right thing in notifying me. I notified Block right away. Okay. In an email. And they informed me that I would have to reissue the subpoena with a corrected email address, which I did. So that's where the second subpoena comes in. But here's what they're saying. This subpoena, they're talking about this first one, March 5th, is included a false attorney contact. Then it says requested information includes legal name, all emails, IP logs, devices, geolocation, phone numbers, full transaction history, linked accounts, and more. Yes. April 9th, 2025. Plaintiff issued a second subpoena with similar demands. This time, she listed her personal email, and it's there. But again, I completed the section for attorney representation despite not being represented by counsel. I don't. Let me just move on by saying it was corrected. It was pro se. The subpoena is contained in these documents, okay? Goes on to say the production dates were listed as April 5th, 2025 and May 2nd, 2025, respectively, both directing document delivery to plaintiff's residence. Now, how does this John Doe person know that that is my residence? Remember, John Doe doesn't know me. Okay, let's go on. In both subpoenas, plaintiff falsely presented herself as legally represented. Not only was a law firm email included, but an attorney phone number was listed to further mislead Block into believing she was acting through a legal counsel. Neither subpoena was served on me, the legal account holder. The subpoenas were issued without court approval while the case is still in pre-discovery. Now, this is an anonymous person who they say they don't know me, I don't know them. They said I didn't subpoena them, but somehow they said that Block sent them an email, okay, notifying them. The subpoena was issued to Block. And if you look through the legal documents, you might find out who else it was issued to or notified of a subpoena. We'll go on. Grounds to quash. Okay, let's take that back up. Hang on. Again, I'm not here to litigate this. I'm here to read it, give my opinion, and to also, well, I've got a lot of work to do, don't I? Grounds to quash. All right, let's go back here. Let me pause for a moment. This is a lot. There's a lot of ramifications even I don't even know yet. But there's just something about this one. This John Doe. I don't know. John Doe does know a lot. Let's look at the address. Let's look at what's being said, these, legal cases that's being referred to. Grounds. What are the grounds to quash John Doe rights? A, non-party with no relevance to the case. How do I know that? The relevance, they're on the Cash App. I don't know that. I don't know if that person is not this anonymous person, Dani Robertson, or not, because they're anonymous. I don't know. Do I? I don't. He or she states, John Doe, I am not a party and have no legal or factual relevance to the claims made. So a sweeping statement there. I am not a party and have no legal or factual relevance to the claims made. My personal and financial information has no bearing on any legal issue before the court. subpoenaing such data from a non-party who is not a defendant in this case is harassing and improper. C. Walker versus City Wilmington, 2016, WL 1704933, D. Delaware, I think that is, or DEL, April 27, 2016. Not a defendant. You mean John Doe wasn't at it? How do we know? Is John Doe a man? So that's under seal with the judge. Maybe the judge needs to see John Doe testify. I don't know. You know, you don't have to live in the state. John Doe, right? He said they don't live in the state, so that's preventing them from appearing. Is that what they said? Let's roll that back. I reside outside of the state and am submitting this motion via the court's electronic portal due to my inability to appear in person. Okay. So that part I get. It's electronically filed. All right. But it says inability to appear. Did the judge ask this person to appear in person? Or they're saying, okay, so, all right, so it's electronically filed, and they can do that. Inability to appear. All right. People can file electronically. That's okay. B. Grounds to quash. Overly broad, invasive, and harassing. There's that word, harassing. Overly broad, invasive, and harassing is one of the reasons given for grounds to quash. The subpoenas request a sweeping list of sensitive personal data, including device logs, email addresses, IP history, phone numbers, geolocation, billing and payment information, and all transaction records. We're going to see if it's stated just like that. These are not limited in scope or time. So, guess what, John Doe, or Jane Doe, or any Doe, or anyone involved in a case? Things can be modified. You know, requests, subpoenas. You know, the judge, it's up to the judge to make the decisions, and the company block to what they release as well. So, yeah, so things could, let's just leave it at that. Okay? These are not limited in scope or time and amount to fishing to a fishing expedition. John Doe doesn't know anything about the case, doesn't know anything about anything related to this. But now John Doe thinks that it's too broad. He or she has an opinion that it's a fishing expedition. It's targeting private information, and they do state a, a case. Let's see what it was. Targeting private information under the guise of civil litigation. See Frazier versus Southeastern Pennsylvania Trans-P authorized 161 FRD 39 or 309 313 EDPA 1995. Next, misrepresentation and misuse of court forms. Wow. Let's see. Under misrepresentation and misuse of court forms, plaintiff who is proceeding pro se improperly completed the attorney section of the subpoena forms. On March 5th, 2025 subpoena, she falsely listed a law firm email address, Arfiga, and a telephone number. Okay. Despite having no legal counsel, let's go on. On the April 9, 2025 subpoena, she again improperly filled out the attorney section, this time using her personal email address, but still implying legal representation. As a self-represented litigant, plaintiff, who was not permitted to complete the attorney fields unless she had licensed counsel. This misuse of the subpoena form misled Block Incorporated into believing the subpoenas were issued under the authority of an attorney. In violation of integrity of judicial process and constitutes sanctionable misconduct under Rule 11. Again, I'm reading this, going through this for the first time in this detail. I got it tonight. Okay. It's a lot to process. I'm not saying yay or nay. I'm reading it and taking it in and saying, there's a lot to respond to. Okay. This meant a misled Block and amounts to bad faith conduct, violating ethical, there's that ethical, obligations under Rule 11, and the integrity of judicial documents. Talk about judicial and legal documents. See Stanley versus Edmonds Leach, 783 F Appendix 837, 10th Circular, 2019. D. Violation of court guidelines and rules. Under the court's practical guidelines, ECF number 10, pages ID 94 through 95, pro se litigants may not conduct discovery or issue subpoenas without court approval. The court, it was sealed by the court. Mhm. Stamped. All right. So, again, this is a lot to look into. Okay. Plaintiff did not seek leave of court to issue discovery, and therefore these subpoenas are unauthorized and invalid. Federal R Civil P45A4 requires notice and proper service. Neither occurred. Hmm. We're going to go on. Because this person says, was never properly notified of the subpoenas. I was deprived of the opportunity to object before Block Incorporated could potentially disclose my private information, exacerbating the harm and necessitating immediate judicial protection. Now, if this person doesn't have anything to do with the case, this person is unknown to me. This person is totally oblivious. This person exists, John Doe, somewhere out in the universe. I'm supposed to know who John Doe is, unrelated to Truth Teller Dani's Cash App that appears on Daniel Robertson. So she's notified, but this person is saying that they weren't notified. Who is this person? How do I know they weren't notified? They're anonymous. Block was notified. They reached out through an email. That's what they're saying. I'd like to see that email and when they were notified, or were they notified by someone else who may have been notified. Let's go on. E. Another reason they say it's grounds to quash. Pattern of abuse justifying sanctions. Plaintiff's misuse of subpoena authority in this manner constitutes abuse of judicial process itself, warranting quashal, sanctions, and protection for the non-party. The combination of issuing subpoenas outside of discovery, well, isn't that discovery? Misleading third parties using false attorney data, not false. Inadvertently put my attorney's email on the first subpoena. My name is the email. Targeting non-party private data, failing to notify or serve the affected person. You mean this anonymous person? Who? How do they get notified? They're never mentioned. I don't know who this individual is. I'm suing Daniel Robertson and Jane Doe's 1 through 10. And yeah, John, we guess we got to put you on there too. A John, a placeholder. Filing repeated improper subpoenas despite prior violations reflects a clear pattern of abuse of process. You see what is the theme through here? Abuse, harassment, violation, all packed under this person who doesn't know anything about the case, anything about me, anything. They just, they're a non-party. But somehow they're connected to this. They are connected to this particular account, Truth Teller Dani, because Block notified the person on Truth Teller Dani, not some person that's not on that account. So this person, while they say they're non-party to the case, that they have no interest. How do I know that? Planting a narrative. It's part of thinking outside of the box and don't know. But there's a history there. There's a history of her saying if she ever has to come before, answer to a judge, she's going to be so persuasive. They are going to be convinced and she is going to win. I don't know how this is going to go, people. I am not popping champagne. I am informing my viewers. This is education. This is informing. And this is a lot of work that I've got to get done. Okay, let me continue. Let's see. It's not me. Let's read a few more. Joanne says she is pressed. Somebody answered this because they don't want this information out there. I see that. Is because they're protecting their privacy? That's what John Doe says. Or are they protecting Danielle? What? I don't know. Do I? This is an anonymous person. But I'm seeking justice in my case. And one of the things that I need to do in order to do that is to discover who this anonymous individual is and those parties related to in the lawsuit. That's what this discovery is. I don't know all the Janes and the John Does. I'm learning. So again, this narrative or in this letter or filing, they say filing repeated improper subpoenas despite prior violations. That sounds very similar to something I think I've heard before. Something about violations. Reflects a clear pattern of abuse of process. Courts may impose sanctions on pro se litigants who engage in bad faith litigation or misuse court resources. See Matthew versus United States 682F 3D 180 2D Circular 2012. You mean if the court can impose sanctions? Misuse of court resources? I wonder who might come. I just wonder what they're meaning here, misusing court resources. I'm a pro se litigant. Bad faith? So she's asking, or he, John Doe, is asking for sanctions as well. Relief requested. Accordingly, I respectfully ask the court to quash both subpoenas dated March 5th and April 9th of 2025 directed to Block Incorporated. 2. Issue a protective order preventing plaintiff from issuing any further subpoenas or discovery requests related to my personal information without prior court authorization. So, in the event that is blocked or quashed, don't allow the plaintiff to re-subpoena, block. Okay. 3, order Block to destroy any documents or data produced in response. So now anything that's out there, and they have timelines when things have to, be opened or destroyed or whatever. John Doe wants destroy that document. Whatever you've sent the first time, lock it, block it, get rid of it. Four, sanction plaintiff for abuse of process, including misleading use of legal forms. Misleading use of legal forms. Violation of discovery protocol. Violation, misuse, misleading, legal forms. Let's park that for a minute. We're not talking about John Doe, are we? Because this is what John Doe is saying. Part of my case, and I know that many people haven't read it, is fraud, legal documents, impersonation. A John Doe certainly doesn't want anything, misleading or use legal, abuse, if anything. I don't either. I want to go by the law. I want to go by the law. I want to protect the integrity of forms or filings or any of that. Okay. 5, order plaintiff not to use, disseminate, or publish any information obtained from the subpoenas outside of lawful court processes, including prohibiting plaintiff from posting, sharing, or otherwise using my private information for public consumption, harassment, or retaliation. Now, John Doe, that almost sounds verbatim to somebody. I don't know. But that if I pulled through my receipts, that might just sound like somebody. I don't know. Posting, sharing, otherwise using my private information for public consumption, harassment, or retaliation. You mean those same things. That have been, wow, y'all got to read this. We'll get to it. 6, seal the movant's identity. Seal it up. Contact information. Don't let the plaintiff know. And records or references thereto, preventing public access or disclosure to opposing parties without prior court authorization. That's a lot. Don't want to know. No contact, no records, no references, nothing. Okay, that's John Doe. That's John Doe. Is John Doe the only person on the account? Who is John Doe? That's an anonymous. I don't know. Is John Doe a company? Who is John Doe? In Atlanta. Oh, I didn't show you that yet. Grant any further relief the court deems just and appropriate. Then they post these exhibits, the subpoena that I filed, Exhibit A in March 5th, saying overly broad invasive subpoena requests. Exhibit B, April 9, subpoena includes plaintiff's personal email but still misuses attorney section. Justification for sanctions. Sanctions are a penalty imposed by the court on a party or attorney who violates court rules, misuses legal procedures, or acts in bad faith. Here, plaintiff action meets this threshold due to misrepresentation, unauthorized discovery, and harassment of non-party. There's that harassment. There's that harassment. Cups of Conversation says, dang, John did all this from an email from blah. Amazing, John. John Doe. I don't know who John Doe is. They're all anonymous. Sanctions may include monetary penalties. She wants the judge to hit me in my pocket. Restrictions of filing future documents or other remedies the court sees fit. Plaintiff has demonstrated a pattern of misusing the discovery process in bad faith. 1, issuing subpoenas without authorization during the pre-discovery phase. 2, targeting uninvolved non-parties. 3, making false representations about legal representation on official court forms. These actions violate both the letter and spirit of Rule 11, Rule 45, and the court's local rules. I'm reading. They have caused unwarranted burden and invasion of privacy to a non party. Accordingly, the court should impose sanctions under its inherent authority and pursuant to Federal R. Civil P11C and 28 USC 1927 to deter further abuse and preserve the integrity of the proceedings. Declaration of John Doe. Seems like John Doe, this template is, I don't know where I've seen this one template. Declaration of John Doe. I, John Doe, declare under penalty of perjury under the laws of the United States that the following is true and correct. 1. I am the legal account holder whose information is being sought through the subpoenas at issue. John Doe, I am seeking the legal information on the account Truth Teller Dani. Danielle Robertson. The account that's associated with Danielle Robertson. Yes. That account that she has posted everywhere. That account that she has received thousands of dollars over, 4-year period. I'm not counting her purse. I'm not. But all of her people, we have sent money to watch videos and do things. They've even had, not raffles, but contests and all that money sent to cash apps and this, transaction and that transaction. So a lot of money, John Doe, has been deposited into your account from hundreds, if not thousands, of people here on YouTube that think it's going to Danielle Robertson. So who are you, John Doe? Do you pay Danielle Robertson? Remember we talked about that. Is she doing this for free? I'm trying to discover who do I need to hold accountable here? It's an anonymous person, John Doe. I didn't just pick John Doe's account out of nowhere, is my point. I'm not doing this maliciously. This isn't an exercise in futility. This person is unknown, John Doe. Just like you are, John Doe. It's not me, says watch her start telling her mods Nightbot to drop a new Cash App account link. If she does that, that's a kind of a sign. She's watching. Danielle Robertson, you're watching. You know this. You've read the summons, haven't you? You know you're being sued. Yeah, you've been served. Yeah, it's follow the money. Let's continue. I am not party to the case, nor do I have any connection to the plaintiff or underlying claims. How could that possibly be? How could John Doe not have any connection if not just by money, if not by the name Truth Teller Dani on the Cash app? How is that possible that John Doe right here says he doesn't have any connection to the plaintiff or underlying claims? Now, we could look at this. Any transaction, if he doesn't have any connection, then Daniel Robertson is doing this for free. The money that everybody is, sending to this Cash app, like for members, or that part goes to Google ad, or, there's different, things. AdSense is Google. Cash App is outside of that. But people use both. And she puts her Cash App up during her broadcast. So you mean everybody is paying John Doe to listen to this person? And this was all set up. Remember, she said, it's been set up. I'm not on anything so that I won't be found. You see, John Doe, is this a way for her not to be found? That someone is on the account that is anonymous, that doesn't want to, be disclosed either, because it might point that there is a connection between John Doe and Daniel Robertson? I don't know who John Doe is. I don't know who Daniel Robertson is, the other Anon. And yes, Dani Robertson, you're watching. I am covering this. A motion to quash the subpoena. Let's go on. John says, I received no notice of subpoenas until contacted by Block. I wouldn't know that unless I know who John Doe is. I don't know that. It's John Doe's word here. I don't know John Doe's address or where things have been. I don't know the relationship between John Doe and Daniel Robertson, although he says, I do not have any connection to the plaintiff, or that is just some mystery. It's not me, says it's two things she's going to make sure she has up: that Cash app and that flame background. She has it in all of her videos. I have it in her videos. I have it as receipts. I have her saying it. I have her thanking people for Cash apping them. So she's thinking, oh, wait a minute. You mean we could go through her videos where she has spoken about Cash App, how she's using the Cash App? So if she's using the Cash App, again, I don't know, but we could go through her videos. She can't take them all down because I got them. And I could go through and see if where she's made references to her Cash App, to things about her Cash App, to either promises made or promises kept about her Cash App, or reassuring her people in any way about her Cash App. We don't know yet. I'd have to go through her videos and look for the clues. Look for any contradictions. Do you see where I'm going with this? Maybe she has said something about her Cash App. Now, people, everybody, let's think. Put on your thinking caps. Help. If you know something, say something. UNWINEWITHTEDDY@gmail.com. Any reference to specifically her Cash App. We need to sort this Cash App thing out. Anything that could contradict either her saying exclusively about that Cash App, anything where she is soliciting or talking about payments, anything related to that Cash App, Truth Teller Dani, anything that you think might be helpful to clarify why it would be that John Doe exclusively has no idea, nothing, has nothing to do with, no connection to Danielle Robertson, because this subpoena has to do with Cash App, has to do with Block. That's what I'm asking for here, okay? So we just need to focus and look for any contradictions, anything that might clarify or point and say, no, it doesn't line up. You can email me at unwindwithteddy@gmail.com. It's 12:16. Let's get through this without going through the exhibits at this point. We're right down to where they've signed. And a few more bullets. The information sought from Block would reveal my legal name, financial records, geolocation, and private identifiers. The information sought from Block would reveal my legal name. And other identifiers. I reside outside of the state of Michigan and am submitting this declaration in support of my motion solely to protect my rights as a non-party. I submitted my contact information under seal for judicial communication only. John Doe expressly limits this appearance solely to the relief requested herein and does not submit to the jurisdiction of the court for any other purpose. Respectfully submitted, John Doe, non-party Movant, appearing solely to quash subpoenas filed under pseudonym for privacy and protection. Dani Robertson motion to quash. Analyze this mess because someone had to say it. I put do it. Say it. Cups of Conversation says, was it filed correctly? These are all questions I need. It's filed. It's on the docket. I just saw it. It was not on the docket this morning. I check every morning. So when I checked today this morning, I didn't see it. So that's like one of the first things I do is check to see if any updates. And then I check at night, like I did. And then I saw it. And then I saw it. It's a real case. Someone responded. A John Doe wants to quash, wants the judge to apply sanctions, make it impossible for me to subpoena in the future to block, or even modify the subpoena, anything related to it. So even in the future, they filed the name under seal. They're an anonymous person. I filed a motion to compel to the company to respond. Now there's a motion that I should be preparing to ask the court. Someone said to strike the anonymous motion. There's other things that I could do. I have a lot on my plate besides this. But I'll continue, as long as I have the stream, to defend my right to due process with respect and in accordance with the law. This is serious. It's not a laughing matter. Not for me. I've taken this step, taking a legal step. So when people said, "Oh, just sue, just what you waiting on, Daddy? Why haven't you done it? It's so easy. Stop talking about it. Do it." Well, when I told people there's a lot involved, and I already had an attorney for other things that have cost me thousands of dollars. Okay? Don't forget, I had my attorney to defend me against a fraudulent request to put a PPO against me last year. Okay? That was thousands of dollars. And until I could get on to first base, as far as retaining my same attorney, I filed as a pro se in lieu of that. Because I have to know where this case, if it is a case, can I get Dani Robertson served? I've spent months going back and forth with this court. It's a process. I don't know every in and out of it. And I've already put money into it. Okay? And I've planned to go the distance. This is not a game. No. Okay. All I'm asking for people to do is, when they come to the chat, be respectful in the chat and understand and be patient, because this takes time. And Also understand, I don't know the outcome of any of this. It's a, step by step. I don't know. I always have to, remind myself. But I also have to remind myself what I've experienced. I already know that. What I've been dealing with, I've dealt with multiple times in different experiences. I know this person is, I'm talking about Daniel Robertson, has the ability and will. So this isn't slander or defamation. Daniel Robertson has misled. Daniel Robertson has abused the copyright system. Daniel Robertson has filed fraudulent claims. Daniel Robertson has put different names and alias names on legal documents. Daniel Robertson has created multiple websites and misrepresented my name. Put my name and said it's my account. Daniel Robertson has filed multiple claims to the medical board more than 10 times. Daniel Robertson has contacted the police and said she was my niece in her own voice and doesn't want that receipt up. Daniel Robertson has contacted multiple family members and sent police to their homes to harass them. Daniel Robertson has said she is going to ruin my legacy for the rest of my life and come after me for the rest of my life. Daniel Robertson has made threats. Daniel Robertson has said a lot of things. Daniel Robertson said she's going to go on YouTube and off YouTube against me. Daniel Robertson has said she'll never be found. Daniel Robertson has said, I always win. Daniel Robertson has said, I lie. Daniel Robertson has made confessions where she has paid people to do things against other people, namely Tales from the Cult and others. I have those videos and I have those confessions. These are just a few of the things that I have, that I know this is what I'm dealing with. I know she can impersonate. I heard her voice on the police recording. She said she was my niece. She doesn't want people to hear that. She said she was concerned for my mental health and that she hadn't spoken to her aunt since the flood, the hurricane. I know she said she's justified, and I know she solicited her followers to harass me. and signed off on it. Mhm. I wouldn't sit here and say such things if I didn't have receipts. I'm in a legal case. She can say she's going to spin things. She's going to say things. She said she's a liar. And she said that she's a fool. She said she's on this platform. She says, I'm a fool, not once, not twice, not 3 times, but 4 times in the same string of sentence. She said she knows what she's doing is wrong, but she gets away with it because she's anonymous. I have that too. And she said she doesn't care because she bullies. She said the bully. And payback is a B. I showed you that. She said, I'm going to pay for it. She said she's out for blood. I have all of this documented, and I have it in her voice. I have her impersonating people to YouTube. I have her saying, you're not going to get any sleep at night. It's legal. I don't know who this John Doe is. I don't. I know I've got to deal with it, and it's 12:31. So I need to respond. My plate is full. It's Wednesday. May. I'm looking at the calendar. Let me roll it up. May 7th. John Doe's document was dated April 25th when it was filed. So, I don't know this. How am I going to identify this person? Even John Doe, for credibility, I don't know. It's just unusual, like I said, and these are things that will be looked into. And I will be preparing a response. Again, this individual, John Doe, just as a reminder, filed anonymously. This fake name, pseudonym, John Doe. Claims to be uninvolved in the case, yet asked to block discovery. Asked to block discovery. Demands secrecy. Wants the court to seal their identity from me, the plaintiff. Objecting to the subpoena. But to file one, I'm learning this is usually must show you are directly affected and identify yourself. I don't know if they're not related to Daniel or not. I don't know. But they say they're not they have nothing to do with this person at all. Any. That's the wording. You saw it. So this person is saying it's not even transactional relationship. Not even a transactional. So it's something about that. It just, I don't know how that happened. So she just gets on here, takes people's bags, brags about taking people's bags, but she's not getting a bag of her own. I just can't add that up. This doesn't square with me. I don't know though. I don't. All right. That's it for me. Yeah, very strange. I just don't know. There will be more conversation to be had, and as I move through this process, I appreciate all of you who had joined me tonight. Baby Juju, Vicky Black. It's late, and tomorrow morning I gotta get I gotta get going. I have to prioritize. So yeah, I'll come on when I can sometime tomorrow. And if I feel great in the morning and I get enough done, I'll come on. But keep your bare phones on. Uh, you know, look at the community wall and email me, which I have not checked my email. Hmm. Okay. Yeah. Tigerlicious. Good night, Teddy. You got this. All right. That's it. Thanks for watching. Until next time, I'm Teddy. Good night. Now, now there was one thing I said I was going to show you, didn't I? An address. I am going to withhold showing that right now, but let me just tell you, it's Atlanta, Georgia. Let's see if I can hang on. What I'm going to do is I'm going to see if I can show you. I'll show you a partial. I will show you a partial. Let me make a quick copy real quick. They filed a separate, I'll tell you, it's notice of contact information submitted under seal and motion to seal contact information. Non-party movement John Doe respectfully notifies the court that his contact information, has been submitted under seal in accordance with court procedures and for the limited purpose of enabling judicial communication. The information is not to be disclosed to the plaintiff or any other parties absent specific leave of court. Although I'm looking at it. Baby Juju said that's why you stay to the end. I don't know. I'm just going to tell you this. Atlanta, Georgia. Okay? I have an address. I have a phone number. I have a Yahoo email. That's what I will tell you. Okay? There's an address in Atlanta with a phone number and a Yahoo email. And the Yahoo email, it kind of follows the same kind of, we'll just say, email pattern kind of that someone else uses. You know, that could be a total coincidence. You know, because people use different emails. But it appears to be a like a business suite of some sort. It's not me. Said, let me guess. The year is included. I'll just say it mirrors something that I've seen before. Okay. And then it says John Doe respectfully proceeds under a pseudonym to protect his privacy as a non-party uninvolved in this litigation. Respectfully submitted. And that's it. All right, folks. I won't show this. I just, talked about it. You can't even guess it. Okay. Georgia's a big state. Georgia. All right. That's it. Again, thanks for hanging out this long. Good night.
어지럽기만 해 이 많은 소음들 그렇게 오는 거야 너의 시선은 깜빡이는 눈이 내게 입 맞춘대 언제 그랬냐는 듯 내 옆에 다가와 Oh 틱톡 틱톡 눈을 굴려보내 힐끔힐끔 또 쳐다보네 볼 듯 안 보일 듯 독한을 보내 날 담기엔 이 밤이 너무 짧겠지 아슬아슬해 보여 이가 날 흔들 때 숨막히는 chemistry 이건 게임이 아니야 너도 알잖아 우리 불 끌었다 그 다음 일 we fight Baby it can burn it up 지겹지가 않아 Just let it flow with me I can't last free 끌어와 내게 가까이 Don't stop when you're older 느려질 틈 없는 긴장 속에 널 다듬어 내 손끝에 놀아나는 걸 알면서도 빠져들어 너 벗어날 수 없게 틱톡 틱톡 잔을 채워 너의 deeper deeper 자꾸 쏟아지네 천천히 조여봐 내 숨결까지 위태위태하게 함께 춤을 추자 아슬아슬